Welcome everyone to our videos previewing our panels at our 2022 FBA Qui Tam conference. It is Lincoln's Law meets the 21st century. I'm Scott Oswald. I am chair of the Qui Tam section. And joining me today is Pam Brecht, who is a partner at Pietragallo, Gordon, Alfano, Bosick, and Raspanti, with a preview of our panel, Private Equity, the newest face at the FCA table. So Pam, tell us a little bit about your panel.
So my panel, Scott, is going to talk about one of the newest players in the Qui Tam space. This is really a follow-on of what's been happening in healthcare and other industries over the last decade. The influence of private equity and their investment in what oftentimes were formerly publicly traded companies has brought these kinds of defendants into both healthcare, defense, all those kinds of things. And with that, exposure to FCA liability. And so I'm going to be joined by Angela Humphreys and Habib Elahi. Angela is a partner in a law firm in Tennessee, in Memphis, in the Middle District, and she handles a lot of transactions involving private equity companies and folks who are in private equity who are thinking of coming into the healthcare space. Habib does mostly defense work in the FCA world, and he's also had exposure to private equity companies as clients and potential clients. And so the three of us are going to talk about sort of the pluses and the minuses of private equity in the Qui Tam space. What are the pluses? Well, there are lots of them, right? They are the new player. If you're going to be doing this work, either plaintiff or defense, you really need to know what their exposure is going to be. And Angela is going to help us in identifying some of those pitfalls during the transaction that you might want to keep an eye on, even if you're not a litigator, to keep your private equity clients out of FCA hot water.
So this is really a hot topic. I mean, we see private equity coming especially into the healthcare space, Pam. And what are maybe a couple things that you as Relators Counsel look for when you've got let's say a hospital system or a medical provider that's backed up by private equity?
So it's all about the details, Scott, and I'm a chronology person. Life happens in chronological order, and so that's where I focus. You know, when did this private equity player come in? Was it before, during, or after the conduct you're talking about? If they came in before, did they have any power to make decisions that impacted the direction the company went to generate revenues? Did they take credit for those revenues that are tied to the very conduct you're looking at? Private equity is very different from publicly traded companies. The way you need to look into their background and the key players is very different than when you have publicly available information about a company that's registered with the SEC. And so you really need to know the who, what, where, and when of each of the people involved, both the private equity firm, those managers or underlings that worked in your potential defendant space, and really know what their involvement was. Because one of the things we're learning is that mere ownership is not going to be enough in this world. It's sort of like being a shareholder in a publicly traded healthcare company. Every shareholder is not liable under the FCA. But folks in the PE space who are actively either initiating or participating in these schemes do have FCA exposure. And there have been several settlements this year that back that up.
And so if I'm defense counsel and I'm thinking about maybe this panel and what I might learn, maybe a key takeaway for me as defense counsel?
Well, there are a couple. One of the things you need to do as defense counsel is see during the private equity transaction, was there an agreement to assign potential fraud liability? There have been some very interesting cases in the Delaware Chancery Court that talks about those things. So you might want to know early whether there's an indemnification right. Who's going to be responsible for defense costs? And does, in fact, the FCA liability shift in the event there's a problem? That's sort of a practical who's going to be responsible at the end piece. But in terms of private equity and defending those, and you know, when do you know? Well, when you get the CID. If you get a CID, you really need to look back and who was active and track those people down, because private equity folks tend to do deals and move on. And so finding out who was involved, what documents they have, and preserving those documents early and often is going to be super important.
Pam, this sounds like a terrific panel. We look forward to seeing you, your fellow panelists, and we look forward to having you at the 2022 FBA Qui Tam conference Lincoln's Law Meets the 21st Century. It is February 23rd through February 25th, each day starting at 12 o'clock. You can register at fedbar.org. We look forward to seeing you then.